compliance with privacy laws like the GDPR in the context of cross-border litigation discovery. And I chair the EDRM GDPR data privacy committee. So that's a particular interest of mine.
Excellent. Thank you, David. And David Wallack.
Hi, my name is David Wallack. I'm lead privacy and security counsel for KeepTruckin. We are a AI company that builds solutions, SaaS solutions and hardware solutions for the transportation industry to make the physical economy run more efficiently and safely. In my role, I'm in charge of all legal and privacy and security matters that really touch the company, whether they are domestic or foreign. So any way that the company touches data, how we handle it, how we store it, how we collect it, who we share it with, and what our global strategies are for complying with an increasingly complex regulatory landscape.
Thank you, David. And Dominic Piernot.
Thank you, Brandon. And good evening from Germany to every one of you joining today. My name is Dominic Piernot. As you can hear, I'm half French, half German. I'm based out of the Frankfurt office of Sandline. I'm the Vice President of Europe. So I'm looking after European clients, European projects, and my specialty is European data privacy, GDPR, and a lot of what we'll be discussing tonight. I'm a guest lecturer at the University of St. Gallen and just came back from today's lecturing, and we had snow already over here in Switzerland and in south of Germany. So kind of a funny situation today with all those time zones coming together, and looking forward to this truly global conversation and discussion with you guys tonight.
Well, thank you, gentlemen. And before we get into the discussion, just to sort of set the stage for what we're talking about today, we're talking about global data privacy, and whether we're talking about individual regulations across the globe, the movement of data across borders, or the collaboration of parties across borders, or even the protection of certain data types within these nations and unions, privacy is an issue that is ubiquitous in the world of eDiscovery and data management today. Because of that, the issues and challenges that we can run into are almost unavoidable in a world in which what we do revolves around the exchange and examination of client data. Now, the map on the screen shows a non-exhaustive diagram of privacy standards around the globe right now. As time passes, this map gets more and more complex. Things crop up, things conflict. We have regulations that sometimes overlap, sometimes are in direct contravention with one another. So I'll start by asking the panelists, when you look at this map and you see the proliferation of different regulations around the world, some of them that cooperate with each other and some that don't, how do you feel about the complexity of this landscape and the direction in which it's growing? To answer that, I'll start with David Cohen. What are your thoughts?
Well, how I feel about it, probably if I was going to pick one word, it would be frightened. There's a lot of complexity, as you said. There's a lot of regulations we have to worry about. I mean, you could have put many more acronyms on this map if there was room for them. But in particular, folks involved on the US side with eDiscovery need to be particularly concerned, because one of the great challenges is that the world is becoming increasingly flat. And so many litigation matters now involve data that's coming from outside the US. And so we've got cross-border discovery issues. And I think many of us litigators in the US aren't aware of the complexity of trying to get data out of Europe and out of some other places that have strong privacy laws, and may make the mistake of just telling a client, oh, send me that data from Germany or from France, not realizing that if you do that, you could be violating a multitude of provisions of the GDPR and subjecting your company to big fines. We'll probably talk a little bit later today about how big those fines can be. So it's a brave new world out there with everything that's going on with the proliferation of data and electronic data, and now the proliferation of privacy laws that are trying to control privacy issues surrounding that data. And the US may be a little bit behind with some of the privacy laws, other than in California, where they have the CCPA and the CPRA, and some other states like Virginia that have new privacy laws. Now there's talk in the US about a national privacy law that may come into play. But we really all have a lot to learn.
Thank you, David. And David Wallack, how about from your perspective from inside the corporation?
Yeah, just to sort of echo David Cohen's comments, it's very much pick your poison out there, right? It is an increasingly complex regulatory landscape. You had already mentioned, Brandon, that not only do some of the laws overlap in certain places or leave gaps in places, but sometimes directly conflict in places. And companies increasingly have to be aware of what David Cohen just mentioned, which is fines for transferring data, even in the context of US litigation. But also companies have to be worried about availing themselves to laws that might not otherwise apply to them if their overall strategy with how they handle data isn't correct, or their overall strategy with how they build out their policies are not correct. Because you can end up being regulated by a law that might not actually apply to you by having sort of a global overarching privacy policy that doesn't take into account any nuances for how your company actually does business or handles data. So that leaves you still, until we come up with some sort of global omnibus privacy scheme, which probably is not very likely to happen anytime in the near future. Even if we are maybe looking at a US omnibus law, it leaves us in the position of having to really treat our data in a very local way. And it means, from the corporate perspective, having very competent local counsel in each jurisdiction that you are actually operating in, and having a strategy that's specific to that jurisdiction, and making sure that you're not sort of, just taking a one-size-fits-all approach.
Thank you, David. And Dominic, what about your thoughts?
Yeah, I think, as the two Davids already mentioned quite well, it's getting complex and complex and complex in the future, in the sense that every eDiscovery project since, and maybe even before GDPR, had a bit of a, as we already said, take data out of the country, put it onto an FTP site and transfer it to the United States, and then some lawyers will take care of it. And GDPR changed the way and the perception of the client as well, right? A lot of the eDiscovery cases we see as eDiscovery provider on a global scale needs to have a clear strategy, right? You're managing several data privacy regimes at the same time. You're managing several local jurisdictional requirements, and at the same time, you're managing the cultural kind of differences of all the custodians, to name an example. Our feeling and our experience of the last couple of years, looking at those global cases and even looking at the local cases here in Germany or here in Europe, is people have a definite understanding of data privacy. There is a reputational damage that could happen to your company if you do things wrong, especially in collections, because your custodians could start screaming at you publicly. And then obviously there is the area of fines, where a lot of big organizations have come into press for not being too careful about data privacy. All that said, it's not the world in which you get an ESI order and you call the data privacy person in a company in Germany, for example, and then they would say, I appreciate the deadlines of the court, go and get the data, will not hinder you. The reality is we're dealing with works counsel most of the time, and it can take ages in a really structured way, because especially looking from the German perspective of things, works counsel can be there and can be tough because they want to understand why you're collecting data, what's happening with the data, and how do you protect the PII information that will likely be in that information set. And the second component to that, and that's even worse, is when you add private information, private usages of mobile phones of the company, or even of the devices or the email boxes that people are using in the cloud. And that's the next component into all that. So that said, we see a lot of cases are threatened by the wrong strategy of the collection, and wrong not meaning that it's faulty, but maybe sometimes things do happen too quick. And our experience and our kind of advice is to make sure that, we as a provider, for example, and the right data privacy lawyers and the right in-house people of the client should be involved as early as possible, because we'll have to navigate certainly a lot of data privacy regimes and regulations to make sure we're not threatening the company and us as a provider by transferring data somewhere, even accidentally.
Thank you, Don. I want to latch onto a couple of things that were said there as you talked about how you feel about the current regulatory atmosphere here. And David Wallack, specifically, you talked about having to treat your data locally now. Can you expound a bit on what that means to you or for your organization? And also, what are the other sort of day-to-day changes or considerations that you have to have when you look at this climate?
Sure. Well, on the localization component of it, and that word has some different meanings to different people, and I'm not just talking about sort of single instancing data and actually localizing it. But for instance, in the United States, KeepTruckin is a B2B service provider. We don't offer goods or services to consumers or households. That gives us a broad array of exemptions under almost every US privacy law in effect, including CCPA, with the exception of how we handle our own employee data. It also gives us an exemption for the time being under PIPEDA, although that may in fact change as Canada looks to maintain its adequacy finding. So we have to be careful, right, in how we actually position privacy policies, for instance, because we don't want to create private rights of action, number one, for certain types of data that we have exemptions for in the US under a B2B exemption. Now, that would be very different under a GDPR style analysis where there is no B2B exemption. So you have to have a different policy for different data types that are located in different geographies, or you might find yourself sort of subject to a whole host of laws that you might not otherwise be subject to. Now, as far as how things are evolving and how things are changing, and whether or not that's a tenable strategy, for the long-term horizon, I'm probably less optimistic about that. I see probably a more uniform approach coming to the way that privacy regulations are drafted and enforced. And I think that we may go towards a place where it simply is just easier to kind of play to the highest bar and say, okay, well, what's the most stringent privacy regulation out there? So let's just build a program that fits that one. And then we'll sort of know that with the exception of maybe a few idiosyncrasies here or there, that we've built out a world-class privacy program that's mostly compliant, and we'll keep an eye out for those areas where maybe we still have some gaps. But we're not really there yet. Too many of the laws are still in direct conflict with each other. There's still too many benefits out there to be had, by not exposing yourself to laws that you don't need to be exposed to. And so I think for the time being that we really are in this place where, privacy is still a very local matter for corporations. And you have to treat it, sort of country by country, jurisdiction by jurisdiction, even in the US, state by state. And so that is a really daunting task, and I think that right now is probably what keeps people up the most at night is, just how is it that I get my hands around all of this? And I don't necessarily know that I have a silver bullet solution for that, other than to say, that you need to have some really good vendors that you work with and some really good outside counsel that you work with to come up with a strategy that fits your particular business model. And just one more thing on this too is, the way that these laws are going to develop, and you can already see this, for instance, in China with some major tech companies pulling out, how they develop and how they're interpreted and how they're enforced and what the rulemaking is and the interpretation that comes out of that rulemaking, that is going to have a major impact on the global economy. And you're going to see companies shift interests based on some of these laws, right? Like major companies are going to allocate or not allocate resources based upon the ways that some of these laws get handed down. And we're no different in that respect. We keep a close eye on these laws, and as we expand, we sort of pick and select, what makes the most sense from us from a lift perspective, based upon what what jurisdictions are friendly for us to operate our business model in, and which ones are more hostile. So these laws are actually, really like they're sort of shifting the deck here about how companies are moving money around and their allocation of assets as well. So it's not a trivial matter by any stretch.
David Cohen, one of the things that David just said in talking about having a strategy, it's echoed both by David and Dom, having proper strategy, is the need for good outside counsel. What has changed in your life as far as being counsel with this much movement on the privacy front?
Yeah, it's changed things a lot, because we didn't used to have to worry so much, at least on the litigation side. We didn't used to have to worry so much about privacy. And the two things that have changed the two biggest things are that there seems to be more cross-border litigation, more international businesses, number one. And number two, the Europeans in particular have gotten serious about enforcing their privacy laws. A lot of the laws that are reflected in the GDPR are really just follow-on to the former privacy laws, but they weren't really enforced, and there were no huge penalties. And now we have a situation where a single violation of the GDPR, you can be fined up to 20 million euros, which is, of course, more than $20 million, or 4% of your company's worldwide annual turnover or gross revenue, essentially, whichever is greater. So that, to me, that's like using a 2,000-pound bomb to kill a mosquito. Every company that is doing business in Europe, and particularly moving data around and processing data in Europe, is potentially subject to those kinds of penalties should there be an enforcement action. Now, with the GDPR, the European data protection officials are so busy, mostly going after the big players, that we have not seen enforcement in the context of cross-border litigation, but I'm sure it's coming. And if I were, I worry particularly for my big clients that have big targets on their backs, lots of money. It's a great way for a small European country to raise a lot of revenue. Go find this big mega technology company for whatever violation of the GDPR you can find, and I'm sure you can find some. So that's of great concern. We as a law firm also have to worry about it, because we operate internationally. We have offices in Europe and the UK and elsewhere. And as lawyers handling data for cross-border discovery, we probably will be considered both processors and controllers under the GDPR and subject to various duties to protect data. And, you mentioned, hire good lawyers. Well, there are a lot of good lawyers who just don't specialize in this area. It doesn't make you a bad lawyer if you don't understand the GDPR. But in my experience, 95% of litigators, including top litigators at my own firm and at other very highly respected firms, just don't understand this. It's so foreign to us, just as our US style litigation discovery is so foreign to most Europeans. The idea of turning over massive volumes of documents and not worrying so much about privacy is very foreign to them, and their privacy laws are foreign to us. So when you start talking to people in the US and you start talking to attorneys about what the laws are, and they start learning that the GDPR defines personal data, not just as the kinds of sensitive things that we tend to worry about in the US, like social security numbers or credit card numbers or bank account information, or personal health information. No, personal data in the EU is anything that can allow you to identify an individual. A person's name is personal data. Even information that about the person's title and company might be enough if it would allow you to identify an individual. So essentially, every document, like 99.9% of documents in litigation, contain personal data and are therefore subject to these very strict laws. So, how that's defined is sort of the first shock to a lot of US people involved in litigation. The second shock is how broad the law is, the GDPR, in defining processing of data. The mere preservation of data in Europe is a form of processing. you can't do anything, even if you don't have a human being looking at the data, trying to filter it in technological ways, which is a way of sort of protecting privacy, cutting out what you don't need. Yeah, that's good. Data minimization is good under the GDPR, but it's still processing, and you need to have a legitimate basis or derogation to do that. So it's a real education process for those in the US who are dealing with these issues. And just to echo one thing Dominic said, I mean, the first thing you have to tell people is stop, be patient, figure this out, get experts involved in understanding this and digesting this so that you don't get yourself in big trouble and you don't end up as the poster child for GDPR enforcement.
David, you mentioned the size of the fines or the potential fines under GDPR. Is it unique in being that punitive when it comes to fining for violations?
I can't think of any other statute that gives so much power to officials for things that can. I mean, obviously the fines, you're not going to get the largest fine for any particular violation, but the amount of discretion that's allowed there, and the fact that the money then goes into these countries and they can go after companies with deep pockets. We've already seen fines in the hundreds of millions of dollars for GDPR violations, not in the context of litigation discovery yet, but I think those are coming. But we've seen some big companies get hit with some huge fines, and believe me, these are companies that spent a lot of money trying to comply with the GDPR. They knew it was coming, and they did make efforts, but they didn't get there. They didn't get far enough, and at least in the opinion of the European officials that found violations. And talking to clients, it's not an easy thing. It's not like you can flip a switch and be GDPR compliant. It is a process. It takes years for a big company. And I think very few companies could honestly say, yes, we are now 100% GDPR compliant. So I'd like to get Dominic's perspective on that too, as an expert in Europe, but I think he'll probably agree with most of that.
Yeah, thank you. And David, if you and Brenda, I'll take it from there because it's a perfect kind of position for me to amplify what you just said, especially from the Germany and European perspective. And as we were talking about 2022, and that webinar today is also meant to be an outlook of what's happening in the future, I think one thing that we can stress today is certainly that the data privacy requirements that we just talked about in litigation, eDiscovery, and investigations are also coming up in M&A transactions in general. A lot of the, let's say, non-litigation work that's happening in this world also has started to have a lot of data privacy components, right? If you look into M&A due diligences, where in most of the European countries, you don't have the consent of the custodian to take over his data into the new entity, it would require pseudonymization, anonymization processes, et cetera, et cetera. And so from our view and perspective as a provider, being engaged in a lot of litigation matters, our technologies and our know-how and our processes are more and more engaged in M&A, antitrust, and all the, let's say, non-eDiscovery specific topics, as you would say, from a focus. But suddenly, most of those regulated projects, especially in regulated industries, have a GDPR component or even an Asia data privacy relevant component. Yeah? So we'll end up being in a lot of legal cases, non-litigation cases in the future as well, where we'll have to use the same approaches to make sure we're respecting data privacy, because company A is looking to company B and end up to be company C after the M&A transaction, right? So we'll see a lot of other demanding parties in the companies and in the law firms that will come by and knock at the eDiscovery, eDisclosure team doors and say, hey guys, we need your technology in order to respond right. Because as you said, David, the fines are high. I'd say from our perspective over here, the worst thing right now is that those local authorities, and I'm just targeting the French ones here, are really active, right? So the CNIL, the French Data Protection Authority, which is kind of a military authority in the meantime, because they have the right amount of people and the right amount of money to do so. They start being the same style than, let's say, the SEC or the FCPA in the UK, or even, well, not the DOJ certainly, but they come and can do down rates, and they really find people like Google, they find people like Amazon for reasons that are understandable, but at the same time, they overrule the Irish Data Protection Authority, which is basically the data protection authority that is looking after those companies, because most of them have their financial seat in Ireland, right? So it's a funny mix of local regulatories and local governmental agencies trying to hit those big national companies in order to get some money back because of data privacy regulations that they don't feel enforced correctly, right? And that brings up a lot of issues and a lot of questions in our clients. So if I go back 10 years ago, obviously the US decision, the US lawyer would go and say to the German, French, Italian client, whomever, we need that data, no matter what, it needs to go to the court. If you don't work well with the court, you will get higher fines, you may lose the court, you get a different ESI order. So please, please, please do whatever it takes. In the meantime, local counsel and the legal departments over here, and I think that applies to the world in general, are like, they're seeing the fines, GDPR, that's one thing, when we look at data privacy and data transfer. But then at the same time, they look at those Google things that the CNIL or that the other data privacy agencies and authorities are doing, and they think, wait, there's this component of me being threatened by my regulation in country, but at the same time, there's a reputational risk for me being threatened by some random Polish, French, Italian, Spanish data privacy agency that will hit me because some custodian that is not happy about the privacy investigation may tell them, right? So that's a funny mix in a really strange way, because we have those emotions in all of the eDiscovery conversations and projects we talk to the clients with. And everyone is kind of scared of, we should have the custodian consent before we do it, because if the guy reaches out to the local data privacy agency, So in the meantime, I'd say it's also a mix of a lot of changing items in the world. Every kind of regulation changes, and suddenly there's always a need for a good outside counsel, and there's always a need for someone who is in country. That's my kind of feeling. And talking about in country, the more we get into those data privacy regimes, the more we add regulations like export sanctions. If you think of a company that would produce, military stuff, the more complexity you have, the more and the quicker you end up of advising your client to take an eDiscovery tool on wheels and to parachute it into the offices of the law firm, of the outside counsel in country, or even of the client. Because in the meantime, it is seen as the ultimate answer to speed up things, to make sure works counsel can sign off the processing, to make sure the data privacy team can say, okay, you can do the legal hold, because as you correctly mentioned, David, in the meantime, in Europe, legal hold is still something most of the legal in-house counsels don't really know how to deal with. So, US regulations hitting European countries and their companies together with data privacy regimes can be really tough. And I guess it's really upon us as technologists in eDiscovery to advise clients, right? Instead of trying to keep them happy and put data into a cloud environment, for example. It will not always work to have eDiscovery cloud approaches for our clients. And that's why we have to have a good mix of tools and a tool belt that we could use for specific projects.
Thanks, Dominic. And David Wallack, if I could return to you, you mentioned a current exemption that you have under PIPEDA that may be going away. And we listened to Dominic talk about the different levels of enforcement with the different nations in the EU. There's so many moving parts here. What's the way from your chair that you keep abreast of where things are going? Where are the dangers? Where are the pitfalls? How do you get the knowledge that you need to manage this properly?
Well, like I said, I think that it's important that you kind of have your A team, right? As far as who you're working with that's handling your data, who your outside counsel is. It's important that you work with really knowledgeable security teams, because you can't have privacy without security, and that's what a lot of this actually really does boil down to. And it's I think you try to take as conservative of a stance as you possibly can on a lot of the decision making that goes into effect. I think, and listen, that we just had an entire conversation about moving data out of the EU into the US for the context of meeting US discovery obligations. The Article 49 of the GDPR has a derogation for the establishment of legal claims extraterritorially to the GDPR. Now, there's a lot of confusion about that derogation out there, and it's why it's not heavily relied on. And it's why there's so much anxiety over transferring data to the US and needing to get protective orders to make sure that it's compliant. And, you know, but it can be frustrating because, the commission is known for a very long time that this has caused a lot of anxiety, and they've done almost nothing to clarify the Article 49 derogation that's existed and that we've debated for years and years and years. And whether that's intentional or an oversight, I don't know. But you know, it can, some of this stuff really could simply be done away with one rulemaking authority simply saying, hey, here is our interpretation of the Article 49 derogation for transfers for legal defense outside of the EU or the EEA, right? I mean, this could alleviate an entire cottage industry of anxiety that has cropped up around transferring data out of the EU to the US. Is just somebody taking some pen to paper and saying, hey, here's what we meant by that, by the way. But you know, I think that really that's all you can do is you know, the fines are so big, as Dominic and David just pointed out, the stakes are so high, you can't gamble on it. You take the conservative approach, you know, and you try to get at the highest levels of your organization buy-in by making them understand that, listen, this can be bet the company. You know, if we, for some reason, are the non-Google, Facebook, you know, poster child, that they decide to come after a middle player, you know, because they want to make it look like, no, we're not just focused, you know, sort of on the big 10 tech companies, you know, that would potentially be a bet the company situation. And when you get them really on that sort of track with you, then you get the extra investment, and then you see some more conservative decisions being made, even if it creates some inefficient workflows, which it often does. You know, and I think that for right now, that's where we're at is, you know, getting from A to B might involve going through, you know, Z and Y first. And so, and that's really the road that you have to take.
David Cohen, one of the things that David just mentioned was the lack of clarity. You know, can someone just explain how you plan to enforce this? Is there anything that you would say you see on the horizon that indicates to you that we'll get better clarity around some of these regulations, or is it going to continue to be, take your best guess?
Yeah, I think that it's not going to be soon or easy. And part of the problem is that you do have multiple countries that are signatory to the GDPR and have their own local rules and their own local interpretations. And one of the benefits of the GDPR was supposed to be bringing greater uniformity to the European Union in terms of privacy law enforcement, but that has not proven to be true, as Dominic pointed out, some of the differences between decisions in Ireland, decisions in France and Germany. So it's not easy, and I wish I could just tell clients, just rely on Article 49. There's lots of, number one, there's lots of debate as to whether that language even applies to US litigation, because there's similar provisions that have been held only to apply to claims and defenses in European litigation, not US litigation. And beyond that, even if it does apply to US litigation, there are still many steps that you have to go through, many hurdles that you have to get over in order to not only process data for starters, but then transfer data between countries, and particularly to the US, a country that's deemed not to have adequate privacy protections. Even though there's some mechanisms, established mechanisms for transfers that are allowed under the GDPR, some of which have been challenged and some of which have been invalidated, like the original safe harbor and the privacy shield, you can still rely on binding corporate resolutions and standard contractual clauses for certain transfers, which are generally, more applied to business reasons to transfer. The big problem with litigation is that you don't get to keep the data under your control because you're having to produce the data to opposing parties, and it can be used in court and it can be made public. So in litigation, one of the biggest concerns isn't that original transfer within your company to the US. You might have a basis for doing that. You might be able to exercise adequate privacy precautions. But then the onward transfers that you have to make when you're producing data to adverse parties or using it for court cases, that creates a whole host of new problems that aren't covered by your binding corporate resolutions or standard contractual clauses. So bottom line is that if you don't comply with US discovery requirements, you're subject to sanctions by US courts. If you do comply, you're subject to sanctions under the GDPR. So you are caught between a rock and a hard place. There is no easy button. We are, I think, in part of this going to talk about some solutions and ways to reduce the chance of getting in trouble about this. And we'll be talking about some of that yet. But there is no easy answer to it. And I don't think there will be. And David, I'm with you. I would love clarification from EU data processing authorities that, hey, you can just use Article 49 to do this. But I don't think we're going to get it. In fact, I think that in places like France and Germany that are pretty hostile to, particularly France, particularly hostile to the US discovery system, if you get any clarification, it's likely to go the wrong way, not the way we're looking for.
I agree with all of that. And you're absolutely right about ambiguity around the intention of Article 49 applying to legal claims outside of the EEA. But I will also just add this. I do think it's creating the very problem that they're trying to avoid, because you know who doesn't understand that ambiguity? Plaintiffs' lawyers and judges. And the plaintiff's lawyer walks in and they hold up Article 49 derogation, right? And it says, you can transfer data for this under this context. And the judge says, yep, it says right there, absolutely. Establishment, defense of legal claims. You can transfer the data. And so you have a lot of data coming over under an article, purportedly under an Article 49 derogation for the context of US litigation that maybe shouldn't be coming over under that derogation. So I do think that they might in fact be creating a problem that they're trying to avoid by not offering clarity on that derogation, even if the interpretation is not the interpretation that we as US lawyers would like to see.
I see a lot of nods of assent coming from you, Dominic. Anything else that you wanted to add?
Well, I mean, we spoke a lot about the complexity, the regulations, how to get data out, because obviously we have to. I think the other element that's something we need to cover today as well is that, you know, looking at our clients, with their systems going to the cloud more and more, and with their systems being distributed even more globally, we're having two challenges here. So the first thing is really, let's assume we go to a client with a server in a rack somewhere and it's physically something that you could touch. And then you can define, okay, we're moving data from Paris to Frankfurt, process it, clean it up, do some PI workflows, and then bring it to the States. That's something that you can explain to someone signing off that data transfer. But nowadays, most of the people and most of the users we see going to the cloud don't really think about what it means for the litigation world, for the eDiscovery world. They know they have a legal hold, they know they may have E5 and Office 365, so they feel kind of relaxed about it. But at the same time, data mapping, which is something that we do with our forensics people in our teams about the case and where is data coming from and where will it flow to and how do we need to protect it and how should we not touch it, et cetera, is getting even complex and complexer, because some of the clients can't even respond quite well to the question, where is the data actually stored? Well, it's in Office 365. Well, in which tenant? They say Europe. Okay. Thanks. So, you know, that's a different angle. That is also something that we'll see more and more in the near future in all the litigation eDiscovery work we do globally, because you know, data sources being more diverse, more distributed, it's tough. And that means the task for us as advisors, all of us basically, is to go back and ask our clients, have they started creating data maps? Not only because something hits them right now and then you do it. No, you need to do it before you have a fire alarm, right? So you need to do a drill. And most of the elements we see critical is really the cloud and cloud encryption and getting stuff out of the cloud and legal hold and mobile devices, and all that together can be really messy, because sometimes, and we just had such a case, you would have an Italian custodian traveling to Germany using a French device under the Irish regime of his company. Interesting one, right? And if you go to Asia, we just had a collection in Taiwan where, you know, other rules and regimes and regulations apply, where you can't take data from the person without having the person sitting next to you and technically recording what you're doing. So there's so much happening where even we need to make sure we're respecting those rules correctly, because at the very end, it could threaten the defensibility of the evidence for us as a provider, and then ultimately for the client and the outside counsel. Yeah?
And David Wallack, how has that changed the growth of the use of the cloud? How's that changed the relationship internally with legal and IT and the corporate strategy around what are you doing with how you collaborate and where you store your data?
Well, I think that it's in the better examples, I think that it has helped to unsilo employees, right? There is very little way to run an effective privacy program at any data intense company without real sort of intermeshing between legal, IT, product, security. They all have to be on the same page. Dominic's absolutely right. I mean, the first step in any effective privacy program is to know where your data lives, right? And that's a very complex exercise. And there are different ways of going about it. It's still a nascent industry. A lot of the technologies that are in the industry are beta prototypes, and there is no clear winner yet. But I think that mostly it's sort of people and process over technology at this point for AI products in the privacy space. But you have to do something. You can't just sit by and wait for a winner to come out. So it's very important to know, where your data is coming in, where your data is going out, and what your regulatory obligations are to that data. Your TPRE program, your third-party risk evaluation program, is of the utmost importance. That is really difficult for large companies to get a handle on, especially companies that might be onboarding hundreds of vendors every single week. To actually have an accurate picture of not only what your data map looks like, but also what your vendor's data maps look like, is, you start to get into infinite complexities. And so, yes, the solution to this problem, it's a tech problem, and it's going to be a tech solution. But you really do, you've got to reach out across almost every single every single department in your organization that handles data. And you have to come up with some type of strategy and figure out, whose roles are what and how you're gonna figure this thing out, because it's a rat's nest behind that TV. I can tell you that for most companies.
And David, Cohen, I wanted to talk about another change that we've seen more recently, along with the growth of the cloud, is now we have a more distributed workforce. Our data isn't necessarily sitting on our own metal in our own data centers anymore, and a lot of our workers aren't sitting in our own offices now. With people working remotely, has that made any change to how you build your processes around maintaining data privacy?
Definitely has. And I mentioned at the beginning of this program that I was scared by the new privacy regulations. I'm also scared by the increase in remote work, because it's a lot harder to keep track of and to lock down systems. And in my case, I oversee an eDiscovery group that includes about 80 attorneys who are now working from home for the most part, reviewing large quantities of sensitive client data. And so we've spent a lot of time thinking about, how do we implement security? We spent a lot of time thinking about that when they were working together, and we had more control over the systems that they were using to access data. But now I think it is another risk. I think that some people have gotten complacent because we have yet to have a huge incident of a data breach resulting from document review being done from home remotely. but it's coming. It's going to happen. Even before work from home, there were data breaches when people worked in an office together, and cyber criminals had to attack more hardened ways of getting to data. It is hard to keep track, and there's things that you can do, and we're doing some things to help lock down the systems that people use to access data and to monitor, but none of them are perfect. There are workarounds to all of them. And every time you add another layer of security, you're usually adding another layer of inefficiency, because the systems don't work perfectly, and they're going to lock somebody's computer up when there are no privacy issues, because they're hard to fine tune those systems. So it is another layer of issues, and where you do see some of the greatest risks of enforcement of privacy laws and some of the greatest potential liabilities and risk exposure for companies, it is where there are data breaches, because there, when the GDPR officials are deciding which enforcement actions to pursue, or even when CCPA officials in California are deciding what to pursue, where you have a data breach, that's going to get everybody's attention. And that's going to be where there's going to be not only remedies based on privacy laws, but also private causes of action. There are some very scary statistics out there about the fortunes of companies that have experienced large data breaches, and many small to medium-sized companies don't survive the data breach. A year or two down the road, they are out of business. And by the way, even some law firms that have experienced data breaches have gone out of business. It's a huge reputational problem. You do everything you can to protect against it, but anybody is naive if they think that they're somehow immune from data breaches or data attacks.
Yep. And maybe just to add one comment to that, David, I think it's just a question of maybe years and months when we see further data privacy litigation growing on a global scale, right? So at the point the French CNIL finds a company and, you put it into a class action style, we'll have a lot of private litigation class actions hitting the market and hitting those clients. And that's, again, a situation where eDiscovery tools and eDiscovery technologies will come and play. Yeah?
Well, we spent a lot of time talking about the problems and the potential risks here, but I want us to be able to have a few minutes at the close here to talk about solutions. As you look at the future of this regulatory landscape, what do you think are the solutions for people who are here listening that can help them be better prepared and maybe put a finger to the wind and divine some direction they're getting out of where things are going? And David, I'll stick with you and see what you might think.
Yeah, absolutely. And I'm pleased to have an opportunity to talk about this, because I spent so much talking about the problems, and my clients don't want problems, they want solutions. First of all, let me mention to people the eDiscovery app, and I think Carolyn has some slides that she can put up. There is an app that's available for download to your smartphone from the App Store or Google Play, the eDiscovery app, and it's got lots of free resources. You can download this app for free. You don't even have to put in your name or any contact information. It's just a free resource. And once you download it, which takes about a minute, you get that map on the left side of this slide here with all these different resources. And a lot of these are very handy for eDiscovery, but we've been talking in particular about cross-border discovery and the GDPR. So if on the cover page you go to selected rules and resources, that takes you to the page that's on the right side there, where you can see the bottom entry there is non-US GDPR. If you click on that, then go to the next slide, and you can see the different resources that are available for free on the eDiscovery app. There's a link to the GDPR itself, but I can tell you, don't try to read it. It's long, it's complicated, and there's hundreds of articles and guidelines. But you can get a quick look at some GDPR summary guidance. I highly recommend a couple of resources here. The GDPR cross-border checklist was developed by the EDRM GDPR cross-border committee, and it gives you a list of about 14 things you can do to maximize your compliance with the GDPR in the context of cross-border discovery. So I highly recommend that. GDPR template notice is a form of hold notice that can be used for European data subjects that tries to avoid some of the sort of automatic violations of the GDPR that could occur if you're using your US style hold notice template. And then finally, the GDPR protective order was also drafted by the ERM committee. And you can see the sort of cover page to the right on this particular slide. And that is a protective order that if you can negotiate that or have a court enter that in the case, it goes a long way towards GDPR compliance. There is no magic bullet. None of these things by themselves are going to take you from being non-compliant to GDPR compliant. But if you follow the steps on the checklist, and if you use the template notice and use a protective order like on this form, then you are going a long way toward GDPR compliance, and hopefully you won't become the enforcement target when they get around to enforcing GDPR in the context of cross-border discovery. So I'll just show the last slide very quickly, which is the get the app part. So if you want to hover your phone over that little barcode, it will bring you to the app, or just go to Google Play or the App Store, depending on whether you have an Apple or Android device, and type in eDiscovery app, and you can download it that way. There's also a web version of the app at eDiscovery, use a dash, e-discoveryapp.com. If you type that into your web browser, you'll get a web version of the app, and I've got it bookmarked as a favorite. But one of the nice things about this app is, especially when you're working remotely, it's nice to have in your pocket and at your fingertips this library of resources, including links to rules of procedure and everything else, and it's all there on the app. So I'll stop there.
Well, and David Wallack, let's move to you and ask, from your perspective, what are the answers or solutions that we have for being more prepared?
You know, I think it's the same as it's always been. I think it's people, process, and technology, right? You have to find people that are interested in this in your organization. You have to find people that are willing to take it on as maybe even sort of in addition to their regular plate of duties. And then you have to come up with processes to respond to the various obligations that you have, not only in privacy, but also in security and cyber and breach. And you have to have those processes in place. And then technology, you know, I am agnostic to the technology choices that people use. I know that there are a lot of great ones out there, and I know that Sandline has great offerings, but you have to find the one that works the best for your business model and is scalable to what you need it to do. And hopefully through, you know, those combination of things of having the right people in the right positions, having come up with the right playbooks for the right matters, and implementing the right solution to help you get there, you know, you'll be better prepared. But no, there's definitely, just like David said, there's no silver bullet for any of this stuff right now. So we're all kind of playing defense, I think, as best we can.
And Dominic, your thoughts?
I think the most important point, looking at all those challenges and all the stuff we learned today, and we kind of repeated, and I think everyone in today's session is aware about all those requirements, certainly, is to select the appropriate team size and to be in relation with the eDiscovery and the forensics provider as soon as possible. And as soon as possible means even if there's a smell of a case, we should start being involved, because the forensics strategy, including all data privacy requirements, when we do need to talk to those specific works council people, to those specific data privacy people in Asia, to those specific outside counsel in that region, is something that can take much longer. And I'm saying that in a really sarcastic way, because obviously sometimes people may tend to say it will take 2 days to get an approval. No, I've seen cases where it took 4 weeks to get an approval from everyone, because most of the non-US corporations that are not into litigious environments don't have a feeling for litigation and eDiscovery. So most of the companies we sometimes work with have their first case still in the year 2021. That means you need to explain, what are you doing? Why are you taking out data? Why do you do images? Why do you do full images? Why is it important to have deleted information to be restorable, et cetera, et cetera. So It's really us trying and making sure that the outside and the inside counsel and the legal department of our clients understand what we're doing and why we're doing it. And that is something that takes a lot of time. And it's super important to have teams that are deployed on the world and that understand and speak to each other. We've seen a lot of projects where teams weren't connected that well to each other. So, the US side would do things, the European side would do things, and then you end up being in a situation where you need to have something like a global lead application, and then suddenly it's not working. So that's my advice, and that should be the takeaway for today's session, at least from our side of things, as Sandline is really engage as early as possible as you can with us so that we can be part of the strategy, the data privacy, and of the requirement discussions with the case. Because I can say on the other week, we had a case with 6 privacy regimes hitting 1 custodian, and it was tough, but manageable.
Thank you, Dominic. Well, we are right at the top of the hour. So to our panelists, thank you very much for the time that you spent with us today and the insights that you've given us on a very, very complex process here. And for all the audience members, thank you for sharing this time with us. And we hope that you got something very valuable out of it, answers for some questions, and for others, some great stimulating thought on things you need to go back and strategize around for your organizations. So thank you to everyone, and have a wonderful day.
Thank you.
Thanks, everyone.
Thank you.
Thanks.